what city and state and address you're going to.
My goodness. You told them.
What happens if you go to Canada?
It'll find you there. It'll find it there too, probably. Most of Canada.
And it just gives you directions?
And it just takes a few seconds. It gives you directions. It knows where you are.
Oh, how can that be? Isn't that marvelous?
And it tells you how long it'll take to get there. It'll tell you how many miles it'll take to get there. It tells you. It talks to you.
It talks?
Yes, it does talk to you. And
what a marvelous thing.
It's just a fantastic.
Well, now we're going to Vernon, Connecticut, which is northeast of Hartford. So what's it tell us what time we're going to get there?
We'll be getting there at 5:47. And
isn't that grand?
38.7 miles away, and it's telling us that in 0.3 miles we're getting off at this exit. Which is
we're going to watch this, folks. Say that again, Lou.
Well, it's telling us that at 220 yards we have to get off. It's counting down 130, 100, 90, 80, 70, 60.
Isn't that wonderful?
And it says get off. And it gives us a picture of where we are, and you see a picture of the road on it.
It gives you a picture, a video?
Well, it's not a video, but it's a diagram there. Don't press that.
No. How do you get the volume on?
Okay, touch the center of the screen. Say change preferences.
Change.
The lower one, middle. You'll see it says change preferences. The arrow on the bottom there, click that. We need to go. Okay, volume preferences, upper left. Now, touch that thing there. Touch that thing. Grab it, and just move it over a little bit. No, not 85. Do it about 60 or so. Okay, let's say done. And this will start talking to us. I believe we have an English lady accent.
Stop! You're going to hit the toll gate.
We hope not.
How much?
Does it pay the toll?
How much?
Not yet. That's the next version.
Oh, it's free. Oh, I didn't know what you were talking about. Yeah. We get to ride for nothing. All the way over
Okay, bear right here. Oh,
we're supposed to go inside?
Yep.
Yep. Everybody's talking about the GPS, not telling me what to do. Why doesn't it tell us what it says? Back up, dummy.
Okay, just follow it and it'll tell us what to do.
That's right. If we make a mistake, it'll tell us how.
4 people in a GPS unit, we make the wrong turn. Okay. See, there's no excuse for lack of intelligence.
It's trying to talk to us, but I can't hear it.
You can't. It may have to go up a little loud. I don't know why. It's.
Well, look at that traffic jam. I think we got to go through that.
Yes, we do. But we'll stay in the left lane.
There you go.
I'm sorry, GPI. I don't want to go to folks, that we got off on the wrong road because we were reading this legal paper, but the machine corrected us and now we're going 91 south, Springfield, Massachusetts to Hartford, Connecticut. Okay, Lou, what's this?
Well, he fools only himself. He does not fool us. This is the day after April Fool's Day. Self-regulation, DR1,
yeah, that's,
103A.
Yeah, that's disciplinary rule. Okay.
Responsibility of self-regulation. The duty to report to the disciplinary committee of the Appellate Division any potential violations of the disciplinary rules that raise a substantial question as to another lawyer's honesty, trustworthiness, or fitness in other respects. Indeed, one commenter has noted that the reporting requirement is nothing less than essential to the survival of the profession.
Oh, this is for you, Pan Hansberry.
And you want me to read the various things there?
No.
Okay.
And then the next paragraph, please.
Attorney General of the State of New York for criminal and disciplinary investigation.
That's what we need.
Pursuant to Section 100.3b3 of the rules governing judicial conduct, sub silentio and without articulation of any reasons therefore.
Now, Chris, this is what you need with those crooked judges up in Warren County.
In permitting accused judges to adjudicate their own case.
Isn't it awful? Accused judges to adjudicate their own case.
In the context of an Article 78 proceeding against them, this court has not only flouted the historic origin and legislative intent behind the Article 78 statute, but has disregarded a vast body of law relative to judicial disqualification, including that incorporated in our state constitution.
Hoorah! We're telling him, aren't we?
And codified in Judiciary Law, Section 14, as well as that which has been constitutionalized by decisional law of the United States Supreme Court, including Aetna versus Lavoie.
That's enough. We told you, Hansberry. Okay, what's next?
An impartial tribunal is recognized as the most fundamental component of the process. He closed his eyes. Where do you go when judges break the law?
Did you hear that, Chris? Where do you go when judges break the law? This is Hartford, folks. And it's all insurance companies.
Mass Mutual.
Oh, this is...
no, not Mass Mutual.
This is not Hartford. This is maybe Springfield.
Is this Springfield?
Yeah, there's Springfield.
I thought we were in Hartford.
Not yet. That's 30 miles.
It is?
Yeah, it is.
What are we on? Oh, there's the Campanile. There's the Campanile and that City Hall and the City Auditorium. Oh, isn't that lovely? We're in Springfield, Massachusetts, folks. And did you hear the woman talking on that, what do you call it, the GPO?
Yeah, the GPS.
She was talking. We're being guided by the FBI is following us.
It's true. The FBI is our co-pilot.
The FBI stands for Fraudulent Bureau of Investigation.
Inquisition.
Okay, Chris. Lou.
Tom Hyland's amount, the default, they defaulted on a judgment of $25 million. They'd rather pay the $25 million than oppose the Constitution. Now we'll see if we can collect it. Who knows? That's the other part of it. Anyway, the last position involves the judge. The judge has to rule on those motions. Okay. Now, as I say, most judges are positioned in themselves. They work for themselves, they don't work for you. They make a lot of money on the side, they have a lot of power, they have a lot of prestige. So anytime they see an opponent that's worthy, they take note of that opponent and they let that opponent speak. Usually. I'm not saying all the time, but in our experience, usually. Okay? Because the judge is concerned about what that opponent might do to him, and the opponent of the judge is you. He shouldn't be your opponent, but that's just the way it works. Well, when it comes to these constitutional rights motions, he has a real quandary. Because if he rules in favor of the motions, it's automatic that you're going to win your case. Period. You're going to win your case. Why? Because all your constitutional rights are going to be maintained. All your constitutional arguments and positions are going to be maintained during that case. Yeah, if you're based in fact, truth, law, and evidence, okay, which is where we're, in your favor, then he's setting precedent for that case in that court, which means anyone else can use those same motions before that court and get the same treatment by precedent established in that court. And we establish precedent all the time, and we use it all the time. Okay? Now, on the other hand, he doesn't really want to rule against, if he has any brains at all. And these guys are not exactly stupid, okay? They're dumb, but they're not stupid, all right? And they're also survivalists. They don't want to lose their positions. So they realize if they rule against the motion, all right, that they put themselves in danger. Because if they're facing a formidable opponent, that opponent could remove them from office. Because the judge, in ruling against the motion, will be denying the Constitution, denying the rights guaranteed therein, including due process of law, denying all your evidence, period. Well, he doesn't want to do that. So usually what they do is neither rule for nor against, but what they will do is find some reason to give you the case. If you're, let's say, a defendant, there'll be some flaw, some procedural error, some this, some that, and you get the case. If you're a plaintiff, the same way, okay? You'll get the case. Because the judge does not want to rule on the motion, period. Now, what we do sometimes is not force the issue. Sometimes we just let it float. When you file a motion, in most jurisdictions, after your opponent has had a chance to respond to the motion and after you've had a chance to reply to his response, the situation requires you in most jurisdictions to file what they call a package, okay, by which you make a request to the court for a ruling on your motion, and in the package you give a copy of your original motion, your opponent's response, and your reply, and in order for the court, okay? Well, when we do this on the constitutional rights motions, we just let it sink in for a decision by the judge. In other words, we don't press the issue. And if we don't see the case dismissed, that's when we are granted, if we don't get a granting in our favor, a summary judgment granting or granting from the bench, which happens many times without any motion on our part whatsoever, then we will put the package together and force the issue. So these are things for you to keep in mind when you're in trial or before you go to trial. And remember,
the city attorney, Mr. City Attorney, are you ready to proceed? And he said, yes, Your Honor, I am. And he looked at me and he said, are you ready to proceed? And I said, no, sir, not at this time. I have a few matters I'd like to clarify before the court. And he said, go right ahead. So I looked him straight in the eye and I said, with all due respect, sir, you and the city attorney have both sworn oaths to uphold the Constitution of the United States of America and the Constitution of the State of New Mexico. Is that correct? And the judge said, yes. And the city attorney mumbled something that was mostly incoherent. And he kind of leaned over his body like this, and I looked at the judge and I said, well, pursuant to those oaths, you are both required to abide by those oaths in the performance of your official duties, especially those before this honorable court. Is that correct? And the judge leaned forward and he said, why, yes, of course. And the city attorney went,
he slumped like this, just like that. And you could hear it coming out of him. And his head was down for about 2 seconds. And then he looked over at me and Margy.
He just went like this
This is your
okay,
case.
We're done here. And of course I proceeded to win the case. And I knew at that point, because of the way the judge responded, that I had placed myself under the protection of the Constitution, and I had invoked the limitations that the Constitution imposes upon the judge and the city attorney, and they had no place to go. Because the issue was, I have a right to expect a fair election, and I have the right to run and to be treated fairly without fraud. And the judge upheld my constitutional rights. And later on we'll tell you the story about my experiences with this judge when I was foreman of the grand jury, which was quite a bit of a controversy between him and me at the time. But it turned out that he is now becoming very constitutionally oriented, and I think we've had a very positive impact on his viewpoints. He said, oh, I know what you mean, blah, 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 blah. Nothing went forward. At that point I said to the jurors, would you like me to directly speak to or write to the judge? And they said, would you write a letter? I said, all right. So I wrote the judge a letter. And I wrote also to the district attorney, and I copied the chief judge. And I told them essentially that we were concerned the targets were not being informed. We would like some kind of statement, certification from the district attorney's office that so-and-so target had been informed that he was, the subject of an investigation, had been offered the opportunity to appear and bring counsel if he so chose. I also raised the issue about the flag and a few other things like jury nullification and educating jurors, etc. Well, the following week after I delivered the letter, we showed up for jury duty, having called the night before and being told it was on. And magically, at 9 a.m. we were told that the session had been canceled, but no explanation. So there was a big flurry. We went outside, and I said, I think I know what happened. I explained I'd sent the letter. They probably had it, and they were like, what do we do now? And I said, I'll give you all a copy of it next week. I had intended to do it at noontime, but we won't be here. So the next session we show up, and the judge comes along with his briefcase and with a look of daggers for me, sits down at the front of the room and nods to the rest of the jurors, looks at me again, and he said, ladies and gentlemen, you're probably wondering why I'm here today. And I thought, I'm not. He said, I'm here today because I received a letter that purportedly is from the jury. And then he looks over at me and he says, Miss Edwards, in the future, please refrain from writing letters on behalf of the grand jury. And I said, with all due respect, sir, would you be so kind as to read from my letter, which I can see you're holding in your hand? First line or two, it basically says that I'm writing on behalf of not only myself, but several of the other jury members who feel the same way as I do. So he picks up the letter and he starts reading it, and basically it says pretty much what I had paraphrased, and his face colors and clears his throat. He puts the letter down and takes a sigh, and he looks at the rest of the jurors. He said, well, who among you knew about this letter? And I'm thinking, this is do or die now. And 5 hands go up. I thought, thank you. And he said, oh, well, let's address these issues because they're very serious. And he proceeded to lambast us that we have no right or authority to question the grand jury system. How dare we? We have to decide based on the information that the nice police officers and district attorneys present to us. And if we can't do that, then we just don't deserve to be grand jury members. And we shouldn't care what happens to the targets after they leave us, because it's not our problem. It's the pettit jury problem. And he goes into a harangue about the flag, how the flag question is a frivolous question. He cites a couple of lowercase decisions that mean nothing to me. And he basically demonized the idea of jury nullification or judges being overstepping their bounds and setting aside valid jury verdicts. So when he finished speaking, he asked if anybody had anything to say. So guess whose hand goes up? And he grits his teeth and he says, yes, Miss Edwards. And I said, first of all, I said, I'd like to thank you very much on behalf of myself, and I'm sure I can speak for the other jurors too, for coming. We know what a busy man you are. I'll get right to the point. I said, first of all, I'd like the cites that you quoted on the flag issue. He said, I'll have them sent to you this afternoon. I said, thank you. So now as to the rest of it. I said, in the first place, I've worked with these people for a number of weeks now, and I know them to be decent human beings. There isn't one of us that doesn't have concerns or care about what we're doing here, because we know that the decisions we make are going to affect somebody's life profoundly and permanently, and we don't want to make the wrong decision. We don't get enough information. We get a one-sided picture, and we're not comfortable with that. And I believe and I know that we're within our rights to demand that these people have been notified. And he kind of looks at me. And I said, as far as our not being qualified to ask questions, that's absurd. We're the jury with every right and the authority and the duty to do so, regardless of what you or any other judge says. We didn't like that too much. Well, I finished up, and when I was done, he thanked me for my comments through gritted teeth again, and then he said, does anybody else have anything to say? And I kind of didn't expect that anybody would, because I knew they were afraid. This was a judge, after all. And this little guy sitting in the back of the room, who was an alternative, who hadn't said boo the whole time that we had been convening, stands up, and he looks at the judge, and he goes, Your Honor, Judge, sir? And he says, yes. He said, I agree with her. And he sat down. And there was a titter that went around the room because it was just so cute and so sweet and so unexpected. And the opposition to your right, you can bring him right back and say, sir, that is not pursuant to your oath. He's already said, okay, I'll uphold it. And if he's refused, you ask him to step down politely.
And what you can do, if any guy refuses to confirm his own, I mean, there are a myriad of things you can say. You want to play it by ear, though, okay? You want to think on your feet. Very important, okay? One of the responses could be, sir, The oath is required by federal law, federal constitution, state constitution. Okay? Without an oath, you cannot serve in office and you cannot discharge any duties of that office. All right? Now, by your refusal to confirm your oath, that would indicate either you're obstinate and have no respect for the people, or you have no oath and no authority to serve in office, or you have an oath and have no intention of abiding by that oath in the performance of your official duties. In any case, you're a traitor to the people, you're disqualified, step down. Hold it just like that. Hold his eye. And don't say a word, just stare at him. Okay? This has happened in 3 or 4 cases in which the judge, stares at the people, gets up, and leaves the bench. Walks away. All right? But you have to know what you're doing, and you have to be not a good actor, you have to be a good citizen. Okay? You have to know what you're doing and be willing to do it.
Mr. and Mrs. Flynn. Yeah, me going this way. And I said, is this a court of record? Behind the closed doors they went. That cost me $3,000. Naturally, how did they rule?
Against you.
Sure. Well, you really can't say.
What are you going to do about it?
Oh, well, that was worth $3,000.
Glendora illustrates a very good point. In most cases, when you have a judge over a barrel, he's not going to say much of anything. Now, if you're not willing to push the envelope, he's going to rule against you.
Who is outspokenly anti-constitutional and unconstitutional and proud of it. He thinks it's a major position to have. And he thinks constitutional people are fools and idiots and morons, okay, that he can sweep under the rug. And this guy is an avowed enemy. He's also a major drug dealer, or he was a major drug dealer in Las Vegas, New Mexico. He's not anymore because he's lost his power. He's been removed from office, which we're proud to say. So he's not going to be hurting other people. And she won this case twice against all these odds and against 3 different sets of attorneys. 3 different attorney firms, not 3 different attorneys. 3 different firms who came and went like thieves in the night because they couldn't take the heat. And this hostile judge, guess what, ruled in Margy's favor twice. Okay? So it's a very interesting case. And this is the case that we have on disc. Okay? There are 2 versions of the case on disc. One is a teaching version and one is a narrative version. The narrative version is something we prepared, and what I mean by narrative is this. Every step of the way is outlined by a narrative explanation of what we did, why we did it, and what we hope to accomplish with that particular motion or pleading, whatever it might be, at that particular move. Now, this can be used by any of you if you so choose, okay? All you have to do is basically understand the concept, understand the motions, understand the moves, use the same motions, use the same ideas in the motions, change the names, change the case letters. Doesn't happen all the time, okay? You have to customize things and adapt things to your specific situation. But basically the steps have been outlined for you. So you have that on disc if you so choose to use it. And if you don't choose to use it for yourselves, it's a good teaching tool for you and for other people as well. So Margy can describe the case a little more.
Okay, this came about in a way that I guess again was meant to be. I had been solicited by mail by Direct Merchants Bank, which apparently is one of the companies that Metra's company is a holding company for. And I really had not used my credit card very much because I don't like credit, but it's good to have in an emergency, or to rent a car, that kind of thing. Well, I ended up being fired from a job which had to do with the Social Security number in a federal case, which I won't get into now. And so at the time, I was short of funds, and I had to use my credit card a few months when I didn't want to. So the balance built up a little bit, not inordinately. It might have been a couple of $1,000s altogether. But anyway, I was making payments on it as soon as I had another job and could. And I noticed that one day there was a late charge on my bill. And I was perplexed because I hadn't been late. So I called up the credit card company and asked to speak to somebody and got the usual, recordings and so forth and pressed this button and whatever, and finally got a live human being. And I was told, well, that's because you were late. I said, excuse me, but I mailed my bill here and it should have arrived within 3 or 4 days, which would still have put me a few days before the deadline, so how am I late? And she said, well, I'll have to get a supervisor. I said, I'll wait. So I wait a few more moments, the usual bells and whistles, and on comes a supervisor and tells me, well, it's not that I was exactly late, it's just that there was a change in the posting date. And I said, could you explain that to me, please, so that it makes sense to me? She said, well, the funds, the payment was here, but it wasn't applied to the account because we changed the posting date. I said, I was not informed of this. So I said, in other words, you didn't apply my payment, so I'm late, and now you're charging me a late fee. She said, yes. I said, I want the late fee removed. She said, well, I don't know if I can do that. I said, I know you have the latitude to do that. You're a supervisor. I want the late fee removed. And she said, okay, I will. And she said, it will be reflected in my next month's bill. And I said, okay. So the next month's bill come, and of course I check, and the late fee's removed. Well, the following month I realized that my interest rate went up from 9 point something to 29. I said, wait a minute. So I call up and I say, what's going on here? Oh, well, you were late. I said, no, I wasn't late. And I went through the whole thing again. Talked to the supervisor. Well, I don't have the latitude for that because that's a policy. But I'll pass it on and I'll see what I can do and I'll be in touch with you. Never heard from her. So I made another couple of phone calls and get very frustrated.